Thanks everybody for joining. My name's Carrie. If we haven't met, I lead marketing here and research content strategy. And I'm sure that most of you are familiar with Gary Cruzy, our managing director of research, and many of you have already spoken to him about the latest developments on MVP. So it's been an exciting couple of days, and we're going to start with sort of a rundown on what's happened to lead us to today, and we'll get into also what we're watching out for going forward. So Gary, let's start. If you can quickly just remind us how MVP was impacted by the Fiscal Responsibility Act, the debt limit bill, which was passed by Congress and signed by Biden in early June.
Sure, Carrie. You really got to go back to about 2018 when the project began encountering very stiff opposition from an organized groups of environmental activists. They were essentially objecting to every permit that the project was required to have from a federal agency and a couple of state agencies in order for the project to finish construction and go into service. And they found a very willing ear for those objections at the Fourth Circuit Court of Appeals in Richmond. In particular, under some quirky rules of the Fourth Circuit, they kept getting the same panel of 3 judges for all of these challenges to all of these permits. And the judges pretty much didn't like any of the permits and kept voiding them. And so Mountain Valley had to keep going back and getting new permits from each of these agencies and then getting those permits voided. So by the time you roll around to late 2022, there began floated in Congress some bills to essentially facilitate the completion of the project by Congress, essentially granting or ordering that all of these permits be issued again. And that culminated, there were a couple efforts to do it in late 2022, but it culminated in 2023 in the debt limit bill with the inclusion of what's called Section 324 in that bill. And basically what that bill does is it required all of the permitting authorities to issue any necessary permits that the project needed to finish construction and go into service, but it also required them to keep those permits in force and effect until the project was in service, essentially. And so the project did, or the bill did pass, and the permits were issued. The thing that the bill did in order to protect those permits from being challenged again is it basically stripped the courts of any jurisdiction over the issuance of those permits. And in particular, it took away all of the jurisdiction of the Fourth Circuit and said if anybody wanted to challenge the part of the bill that essentially stripped the courts of jurisdiction, it would need to do that in the DC Circuit. So that's where you were after the passage of the bill and the completion of all of the permits. You basically were poised for Mountain Valley to begin construction, and essentially under the bill, at least, there would be no role to play for the Fourth Circuit. But to the regret of Mountain Valley, there were a couple of appeals still pending at the Fourth Circuit. And in both of those appeals, the environmental groups had asked the Fourth Circuit to stay the permits that had been issued. One of them was a crossing of the Jefferson National Forest permit, and the other one was a biological opinion incidental take statement that allows the project to operate in areas where there might be impacts to endangered and threatened species. Both of those applicants or objectors to those permits had requested that the court issue a stay of those permits while the case is being considered. And then late last week, they actually asked for an administrative stay for the court to hear the arguments on the full stay. And so that's where we were going into last Friday evening. And, you know, last Friday evening, rather than just issue an administrative stay, I'm sorry, no, now I'm getting my days confused. On Monday evening, rather than just issuing an administrative stay, the court in two of those cases, both involving the Jefferson National Forest crossing, at 5 p.m. on Monday evening, they issued a full stay. So not like some people have reported, it was not the administrative stay that was issued. It was a full stay. And what that essentially means is those permits are stayed while the court considers the merits of the case. So that's where we were last night. And then this morning, the court issued another stay with regard to the biological opinion incidental take statement. And so now two of the permits that the project needs to continue construction have been stayed. Neither of the stays actually stay construction, they stay the effectiveness of the permits. And that might be important going forward here because you know, FERC's going to have to figure out what to do about that. I don't think FERC will interfere in trying to dictate what the project can do. They will leave that to the project applicant to figure out how they can operate within the confines of not having those permits. So principally because the statute ordered FERC to continue to allow the project to construct. So I don't think FERC wants to get involved at this point.
Okay.
That's where we are.
So at this point, folks, if you have any questions on anything thus far, reminder, the QA, you can submit questions there and we'll anonymously moderate. Did the court then, so assuming we're not on a fast track to a decision here about these stays, what's the timing?
Yeah, the court could have, at the time it issued the stays, it could have issued an order directing the appellants and Mountain Valley and the government to file promptly their briefs about this permanent stay or about the substance, the merits of the case, so that they could reach the merits quickly. But they didn't do that. So in a typical case, you're talking probably about a 9-month period from the time the appeal gets filed until it's heard and a decision is rendered. So you're probably talking early next year if you just progress along that timeline. And throughout that time period, these stays would remain in effect.
But do you think there's a way the project developer can get the stay lifted? Yes,
there's probably a number of them. I'm sure the project developer is talking about every one of them. The most likely one that we would expect to see is some filing at the U.S. Supreme Court asking the court essentially to stay the stay. So in other words, the Supreme Court would lift the stay and allow the project to proceed while the appeal was processed.
Okay. And so tell us about this new lawyer.
Yeah, so it was a busy day on the 10th of this month. In addition to a lot of briefs being filed on these stay motions, Mountain Valley entered the appearance of a new lawyer, Donald Borelli, who is a former Solicitor General and one of the most respected Supreme Court appellate lawyers. So they perhaps knew that they needed the extra support for this potential of a Supreme Court appeal. And so he is now one of the attorneys of record there in the Fourth Circuit. It wouldn't be a surprise if he's the one helping them formulate what they're doing to overcome these stays by the Fourth Circuit at this point.
Okay, so how does that process work if the Supreme Court's going to get involved here?
Yeah, so basically, what you do is you file an emergency request with the court. Those are referred to a justice based on sort of, every justice is assigned at least one of the circuits. The justice assigned to the Fourth Circuit is Chief Justice Roberts. So it will initially, that emergency application would initially go to Chief Justice Roberts. But in most cases like this, he would refer it to the whole court, and the whole court would then decide whether to stay the stay. In order to do that, you're going to need to find 5 votes willing to step in at this early stage of a proceeding and stay the lower court's decision. And that will be the difficult part of getting that process approved by the Supreme Court this early.
So difficult, but possible.
Yeah, I mean, there's a case that's cited in a lot of the briefs that were filed at the Fourth Circuit by the name of Patrick versus Zenke. And it's a very similar case to this one, where Congress passed a statute to essentially take away the jurisdiction of the courts in order to confirm the transfer of title to a piece of land that an Indian tribe wanted to put a casino on. And a neighboring landowner had objected to that transfer. That went all the way to the Supreme Court on the merits, not just on a stay request. The problem that MVP faces is it was not a very organized decision. There, of the 9 justices that were on the court in 2018, it was split 4-3-2. So no single basis for why they upheld the statute got 5 votes at that time. And based on the 6 that remain on the court at this time, Roberts and Gorsuch were very much against the stripping of the court's jurisdiction in that case. And we think they probably would have the same viewpoint on the statute that stripped the Fourth Circuit of its jurisdiction in this case. Thomas, Alito, Kagan, and Sotomayor, based on their opinions in that case, although they sort of differed on the reasoning for why the statute could be upheld, the same reasoning that they used in their opinions would apply to this case. So they might be willing to uphold Congress's power to strip jurisdiction here. The problem is that the 2 liberal justices in that group, Kagan and Sotomayor, don't really like this, what's called the shadow docket at the Supreme Court, where the Supreme Court acts prematurely and issues a stay of a lower court decision. So it's unclear to me that Kagan and Sotomayor would be willing to step in at this early stage and cut off the process at the lower court. And then that basically leaves us with the 3 justices that were not on the court at that time. That would be Kavanaugh, Coney Barrett, and Brown Jackson. And, we don't really know where they stand on this question of jurisdiction stripping by a congressional act. But the 2 of the 3, the 2 conservative justices in that group, Kavanaugh and Coney Barrett, seem willing to use what's called the shadow docket, or this emergency docket system, fairly regularly. So they might be if they think that this statute is constitutional, they would probably be willing to join with the other 2 conservatives to issue a stay of the stay. That still leaves you 1 vote short, and it would probably be necessary at this point to get one of the 3 liberal justices to join them to grant the stay of the stay. So that's sort of the uphill battle they face. Again, the benefit is Donald Borelli probably knows those 9 justices way better than I've just described their viewpoints, and can probably craft an argument that cobbles together the necessary 5 votes. But that will be his task, is creating some argument that can gather 5 votes for a stay.
Okay. Surprised we still don't have any QA questions. So You must be describing, oh, I spoke too soon. Okay, we do have a question on the Supreme Court. So will the Supreme Court hold public hearings or arguments if the stay isn't lifted prior to the next term of the court?
If the stay is not lifted, the normal process would be a very slow one. So, like I said, if the stay is not lifted, it would stay in place until probably early next year when the court renders its decision on the merits in these two cases. And that would be pretty late in the term. So the Supreme Court term runs from October to June 30th. And so if the Fourth Circuit doesn't make its decision until, let's say, first quarter of 2024, that's very late for there to be an appeal to the Supreme Court and the Supreme Court to hear it. They stop hearing arguments probably in April. So it would be very difficult to get on the Supreme Court's argument calendar. So likely, if it goes the slow vote process, the Supreme Court wouldn't hear it until their term that begins in October of 2024. And yes, if that process goes through and the stay is not lifted, then yes, there would be briefing and oral argument. It would be a full merits decision at that point on whether essentially on reviewing the decision of the Fourth Circuit. But again, even at that point, Mountain Valley isn't guaranteed that the Supreme Court will take the case. They still have to convince. In that case, if you're just seeking a petition for review, you have to convince 4 justices that your case is worthy to be reviewed by the Supreme Court. So a little lower standard than the stay being lifted, but you've got to convince 4 that what the Fourth Circuit did was wrong. So that's assuming the Fourth Circuit, and I think everybody's assuming this at this point, that the Fourth Circuit finds that it has jurisdiction in this case, despite what Congress and the president said,
Right.
And that it finds something wrong with the permits that were issued. And those would be the 2 conditions that would require Mountain Valley to seek further review by the Supreme Court. I guess it's possible that they uphold the permits, but I don't think anybody thinks that's likely.
So there were 2 other permits that have been issued and reissued that haven't been appealed yet. Are you watching for that?
Yeah, so that would be, the West Virginia Water Quality Certificate actually got voided before the statute even was passed by the Fourth Circuit, of course. And so what happened is West Virginia reissued that permit after the statute was passed. It's not a permit, it's a water quality certificate. That allowed then the U.S. Army Corps of Engineers to issue its 404 permit and incorporate the terms of the water quality certificate. So both of those decisions could still be appealed. And given the fact that the Fourth Circuit seems to be handing stays out like candy, I wouldn't be surprised if the organized opposition goes ahead and appeals those 2 decisions as well, because they have not yet been before the Fourth Circuit. So
Relatedly, we had a question, hasn't the Fourth Circuit already claimed jurisdiction simply by issuing a stay?
yeah, essentially that's the problem is, I mean, at the same time as was pending the stay motions, both the federal government and Mountain Valley had filed motions to dismiss the entire proceeding because of the lack of jurisdiction. So that's essentially what will be the subject of the appeal to the Supreme Court, is by essentially taking the case at all, that the Fourth Circuit has already in many ways decided the case. And so that's why the appeal to the Supreme Court actually has some legs, I think, in getting the attention of the justices. The problem is if the justices agree that what the Congress and president did is unconstitutional, that they couldn't strip the court of its powers, then you're not going to get the Supreme Court to review that decision because they basically agree with it. So that would be a problem.
Can we go back to the shadow court that had another question? So would you revisit that?
Yeah, so what the people refer to it as the shadow docket. It's essentially an emergency docket that the court has always had. Most of the things that go through the emergency docket are routine things that nobody cares about. The one that human beings care about is stays of execution come through that docket. So essentially, anytime somebody's about to be put to death on death row somewhere in the country, an emergency application gets filed with the Supreme Court to stay that execution. So those types of emergencies come through that docket all the time. What most people refer to when they talk about the shadow docket is the Supreme Court has recently, probably since 2017, begun to entertain motions to stay lower court decisions or overturn stays of lower court decisions before they've ever had a chance to really get briefed on the full merits of the case. And so that's what these emergency petitions ask, is that the Supreme Court take a position on the lower court decision before they've had a chance to be briefed on all of the particulars of the lower court case. And so that's why it's called a shadows docket rather than a merits docket, because they haven't really seen the merits yet. It's living in the shadows of this sort of emergency docket that, to the point of the earlier question, there's really not oral argument and briefing, full briefing before something gets decided. An order is issued on the shadow docket. And typically the orders are very brief. In fact, they're almost as brief as what the stay was that was issued by the Fourth Circuit. It basically would say something like, based on the pleadings, we hereby stay the lower court decision. And that's it. So there's no opinion unless a justice objects to the stay being issued. You know, you don't get any idea of who voted for it or how it got voted through. So often that's why it's called the shadow docket. It's just kind of opaque. You don't really know what the process is and who voted for what. But it has become something that, especially I guess the viewpoint is that it has become a tool of the conservatives on this current Supreme Court and is often bemoaned by the liberals on the court. So that's why I don't think it would be hard for the two liberal justices who may be sympathetic to Mountain Valley's argument that this statute is constitutional. It may be hard for them to then use the stay powers of the court and the shadow docket to stay the lower court decision, because they've been sort of opposed to the use of these stays in other cases. So it may be difficult for them to get to that decision.
Okay. So back to, the FERC that authorized construction, right? But then we had the stay, and then this morning we had the biological opinion and incidental take statement as well. So we had a question just to clarify what can be constructed right now.
Well, as I said earlier, I think FERC's probably going to leave that up to Mountain Valley Pipeline to decide. I don't think FERC will probably want to wade in here and issue a stop work. I think what they will expect Mountain Valley to do is only work within areas where they continue to have authority. So it's clear that they don't have authority right now to work in the Jefferson National Forest, but that's only about 3.5 miles of the pipeline. It's about a quarter of the spread that it's in that it still needs to be trenched. So, but that 3.5 miles is not big. The other part, the biological opinion, impacts a broader range of areas. It would impact anywhere where the biological opinion of the U.S. Fish and Wildlife Service determined that there could be a negative impact on threatened and endangered species. But again, that may be a very small area at this point. A lot of the biological opinion was focused on tree clearing. Almost all of the tree clearing has been done. Water crossings could be a problem, particularly in areas where there are threatened endangered species in the water that might be either their habitat or the species themselves could be degraded by turbulence released during the water crossing. So I think it will be up to Mountain Valley to decide what areas, that they still are constructing in, cannot be constructed in. I think that's why the other thing we'll be listening for is Mountain Valley's response to this, whether they order a complete stand down or whether they continue to construct in areas where they continue to have full approvals. So
Sure. Can we move into in-service a little bit? Which
Sure.
I know, just a teaser, we're going to be writing about MVP again on Friday for your Arbo Insight.
Yeah, and I'll have a better odds chart than the one I'll present now, I guess.
Okay.
But so the way I'm viewing it right now, the most likely immediate way to stay almost on schedule. So we had already been saying first quarter of 2024 was the most likely result here. The company is still saying end of 2023. So we're not that far off. If they can get a stay request filed with the Supreme Court and the Supreme Court can act on that, if you look back at some of the ones in last year's shadow docket, the Supreme Court acted on them typically within a month after the application for a stay or something was filed with the emergency docket. So the only issue there might be that the Supreme Court is on recess essentially between now and October 1. So again, it may be difficult to sort of round up the 5 votes they need. But so that might take a month, let's say, for them to file and get an emergency stay of the lower court stay. That would mean they would probably only be delayed a month. So just add a month to whatever your current projection is for the in-service date. If they don't do that, if they are unable to get such a stay from the Supreme Court, the other thing they may be able to get either from the Supreme Court or from the Third Circuit itself is an expedited decision on the question of jurisdiction. Because as somebody indicated, merely by ruling on the stay, essentially the Fourth Circuit has decided they have jurisdiction. But that is one of the key questions in the case, is do they have jurisdiction? And that doesn't take any substantial amount of argument. That is purely a paper decision about what this, I mean, there's very little doubt about what the statute says. There's very little doubt about what words the statute uses. It's really a question of, is that a violation of the separation of powers in the Constitution and a stripping of the court's jurisdiction that is inappropriate? So they would, I would think they would be seeking a quick decision on that they could then take to the Supreme Court and get it there before the Supreme Court still in this term that begins on October, which would mean they could have a decision from the Supreme Court. Again, assuming the Fourth Circuit rules against them, they would have a decision from the Supreme Court by the June 30th, end of the next term. If they could do that, then they could be in service by the end of 2024. I've seen some press indicating that this is a 9-month extension of the in-service date because of the time frame for appeal.
Right.
I just think 9 months is probably the least likely result here, primarily because what that assumes is that the Fourth Circuit takes its normal time to process these cases, come to a merits decision, but then it assumes they rule in favor of Mountain Valley. And I can't imagine this court issuing a stay, taking their jolly old time, and then approving the permits. So,
Right.
the odds of a 9-month delay seems to me to be remote at best. It is far more likely that the next level of delay would be where they take their jolly old time, they revoke all of the permits,
Yeah,
and then Mountain Valley has to file the jurisdictional question with the Supreme Court, and that goes through the normal process. So that's the one that gets you into a hearing before the Supreme Court, probably in its October 2024 session, which would mean they may not get a decision until June of 2025. And that means they aren't in service until June of or December of 2025. That's sort of the best worst case, I guess, for Mountain Valley. The worst case is that, you know, the Fourth Circuit takes its jolly old time. They take 9 months. They rule against Mountain Valley's permits. Mountain Valley takes that up to the Supreme Court, and God forbid the Supreme Court agrees that Congress didn't have the power to pass this statute, and sends it back to the Fourth Circuit and says, now you have jurisdiction over these permits. We know what that means. We know these permits will never get approved. And essentially that means Mountain Valley is dead. So that the sort of worst case scenario is that the Supreme Court upholds the fact that the Fourth Circuit still has jurisdiction over this case. And that pretty much would probably be the death knell for Mountain Valley at that point.
okay. I'll give people a couple more minutes here to ask questions. One is kind of asking for a recap of the two most likely scenarios being either 1 month delay or a 2-year delay. Is that a correct characterization?
Yeah, I would. Yeah, I mean, if those will probably be the ones that end up with the highest percentages,
Yeah.
Of all of the scenarios. Probably a close second/third is that there is somebody orders an accelerated decision on the jurisdictional question,
Okay.
the statutory question. So that would probably be a close second or third to those other two.
Okay. So just to recap, then how would you, summarize what we're watching for in the next, what period of time?
Yeah, so I think you need to be watching the dockets, and we'll be watching those for you, obviously. The dockets at the Fourth Circuit to see if these other permits get challenged.
Yeah.
You need to be watching the dockets of the Fourth Circuit to see if there's motions made to accelerate briefing on the jurisdictional question, so that we can get a resolution more quickly. And then obviously you need to be watching to see if Mountain Valley appeals to the Supreme Court seeking an emergency stay of the stay. I think those are the three most likely things that will happen in the next, I mean, they could happen very soon, in the next day to a month, probably.
Yeah. Okay. Super helpful. Well, folks, you can reach Gary at gary@goarbo.com. For those of you that don't already have him on speed dial, you can find our numbers also on the Arbo website, or you can feel free to submit a contact inquiry on the Arbo website. Super grateful for your time today, Gary, and thank you to all who joined for the discussion, and have a great afternoon.
Thanks, everybody.